Right, the first Pakistani proceedings, is that where we are?
First Pakistan proceedings, indeed. You need for that, my lord, bundle E. And these were launched on the 20th of January 1997. And if you go to A1, which is the plaint, I'll just take you to a few paragraphs. You see it's the trust established under Section 3 against Dallah, and the suit is for a declaration to the effect that the agreement stood repudiated on account of the fault of the defendant, and then it sets out what was in the letter effectively, and about 6 lines up from the bottom, and as a consequential relief for permanent injunction, restraining the defendant from claiming any right against the plaintiff under the said agreement, or representing or holding out that the plaintiff has any contractual relations with the defendant. And in paragraph 1, over the page at page 2, the Secretary, Religious Affairs Division, Government of Pakistan, is the Secretary of the Board of Trustees constituted under Section 5 of the Ordinance, who is fully conversant with the facts of the case and competent to sign and verify the plaint.
So it's in the present tense?
Yes. We'll see how, in fact, it is verified as well, and we will see in a moment an inconsistent verification a few months later. Paragraph 5, purpose of launching the aforesaid Mecca housing project, the parties entered into an agreement dated the 10th of September, and then jump to paragraph 10, that under clause 4 of the agreement, the defendant was also under an obligation to submit detailed specifications, but the defendant failed to comply with this fundamental term of the agreement, which tantamounts to a repudiation of the whole agreement, which repudiation was accordingly accepted by the plaintiff, vide its letter of the 19th of January, that on account of the repudiation, the same is no longer binding on the plaintiff, defendant not entitled to raise any claim or right against the plaintiff under the agreement. 13, that the cause of action accrued to the plaintiff against the defendant as Islamabad, firstly when the defendant entered into the agreement, and thereafter when it defaulted in fulfilling the preconditions of the agreement, and the same was repudiated, and finally yesterday when it refused to treat the agreement as repudiated. And then a prayer for relief. And verified on oath 20th of January. Now, just pausing there before I take you to the affidavit, a couple of points to note. Obviously, it is clearly based on the letter because the letter gives the cause of action.
Yes.
Secondly, what it is being sought effectively is an order to say not only a declaration that there are no contractual relations with the plaintiff and an injunction. Remembering, of course, that at this stage Dallah has in fact done nothing other than write the letter of the 20th of November asking the government what's happening about the financing. And you get a similar document, suit for declaration, in tab 2, number 5, pending the decision of the suit, if the respondent is not restrained from representing or holding out that the applicant has any contractual relationship with it, the applicant would suffer an irreparable loss unspecified. And then if you go to 4, you have Mr. Mustafa Muhammad Lughfala being Secretary Board of Trustees, Awam Trust / Secretary Religious Affairs Division, Government of Pakistan, to hereby take oath and state as follows. Read the application, moved under section 151. This is by Dallah. I'm fully conversant with the facts of the case and to the reply have been prepared under my instructions. The facts stated in the aforementioned reply are true and correct to the best of my knowledge and belief. The allegations made in the affidavit against Awami Trust are absolutely false and the same vehemently denied. The facts stated in the plaint are true and correct to the best of my knowledge and belief, and the same are reiterated.
And where's Mr. Raza's affidavit?
We don't have Mr. Raza's affidavit. All we have is the reply, well, the response to the reply.
It would be quite interesting to see it, wouldn't it? The application referred to in tab 3 and tab 4, and the affidavit in support of it.
I think it was an application under Section 34 of the Arbitration Act. I'm afraid...
But it must have been addressed to the trust.
Well, one would assume it may well have been, but of course it might, at that stage my clients may well not have known that the trust didn't exist.
So there can't be any common intention at that stage to make the government of Pakistan a party.
Well, with respect, my lord, at that stage, this was an urgent application for an injunction. My clients would be responding to proceedings which were brought against it. You will see, if I go on in a second, that the issue then does arise that the trust is no longer in existence. And if you look, because we don't know what went on, but what we do know is at flag 5, the judge says, counsel for the defendant had objected at the last date.
Where are we looking?
A flag, little 5 of 1.
Just before we do that, though,
Yes.
Mr. Raja's affidavit
Yes.
was in support of what application?
I believe it was in support of an application to stay for...
By Dallah, to go to arbitration.
To go to arbitration.
Yes. So it was an application against the trust to go to arbitration, as I think you accept.
As I understand it, as Lord Manson.
On the basis that the contract was between the trust and Dallah.
Well, my lord, that may be in relation to the position of the trust, but of course, remembering at that...
I was talking about the position of Dallah.
Yeah, but Dallah would respond in the proceedings to the claimant who had brought the proceedings. It is true that at that stage...
Which was the trust. At any rate, appeared to be the trust.
But it is true that at that stage, they did not join the government.
So everything that happened in these proceedings to date was consistent with the idea that the two parties to the contract were A, Dallah, and B, the trust. That's on the face of it.
Well, on the face of it, but it may be consistent that the trust was a party. It may not be the sole party. But also, my lord...
Well, that's why it'd be interesting to see the application.
Well, I can't... I mean, we may be able to find it, but
It must see. On the face of it, it presumably exists somewhere.
we will endeavour to see if we can find it.
What are we looking at, tab 5?
We're looking at tab 5, the judgment, because we are here on the 21st of February.
Yes.
Counsel for the...
A year later.
98, isn't it?
No.
Tab 5 is a year later.
Oh, yeah, I'm sorry, tab... Yeah.
Is that because I thought you mentioned tab 5?
Tab 5, yes.
Was I wrong? I mean,
Counsel for the defendant objected to the last date of hearing that Amwar Trust was established under Section 3 of the Ordinance, 1996, but at the time of the institution of this...
Sorry to interrupt you. This is the judge, is it?
This is the judge, yes.
On what form of application? Do we know that?
This, I've always understood to be the judgment in relation to this suit for the declaration started on the 20th of January 1997.
Yeah, I'm not saying that's not right. What is it, a judgment on the application for a stay or what?
Well, I think it's a judgment on the application for everything, because effectively what he says is that the claim cannot be maintained because the trust no longer exists.
And who was arguing that?
Well, it looks as if, it's not clear, it looks as if it was raised by Dallah, but again, it's not clear from what we have.
Well, it seems to be crystal clear. Dallah raised this point at a late stage in the proceedings and won on it.
Yeah, well, that seems to be the position. Dallah, as objected, was established, but at the time of the institution of this suit, the ordinance had elapsed. And it may be the position, I don't know, that when they first put in the response, after all, they were asking for an urgent injunction. The position may not have become clear, but it was obviously became clear later. But at the time of the institution of this suit, the ordinance had lapsed. There was no more ordinance in the field, and suit had been filed on behalf of the same, which was formed when the ordinance under the ordinance after the lapse of ordinance. Anwar Trust is plaintiff in this suit. After the lapse of the ordinance, the present plaintiff was no more a legal person in the eye of the law. This suit has been filed after the lapse of this ordinance. In other words, suit has not been filed by the legal person as plaintiff after the lapse of the trust ordinance. Counsel for the plaintiff conceded from the arguments that suit had been filed after the lapse of the trust ordinance, and the plaintiff in this suit is Awami Trust, established under Article 3 of the ordinance, 1996. But counsel for the plaintiff has argued that after the lapse of the ordinance, the thing during the life of the trust do not stand abated. But this became alive even after the lapse of the ordinance, so no suit has been filed by the competent legal person. After hearing arguments of the counsel for the parties, I'm of view that the lapse of the trust ordinance, the present plaintiff trust, is no more the legal person, because the present plaintiff has legal entity only during the life of the ordinance. When the ordinance was lapsed, the present person was no more legal person, and suit was filed after the lapse of the ordinance by the trust. Moreover, the things done during the ordinance can be sued and can sue by the parent department from whom this ordinance was issued by the government, and that was Ministry for Religious Affairs. Suit should have been filed by the Ministry of Religious Affairs. In this way, I hold that the present plaintiff was no more legal person at the time of the institute of the suit, because the ordinance had lapsed at the time of the institution of the suit. Before parting with this order, I observe that the liabilities and duties against the present defendant can be agitated by the Ministry of Religious Affairs, Government of Pakistan, if any. Since the suit has not been filed by the legal person, the present plaintiff is no more a plaintiff in the eye of the law. Suit is dismissed. File be consigned to the record.
Record room.
It looks as though it was your clients who took the point.
It looks as if my clients took the point. We then move forward to...
It's slightly less clear what point the government was taking. But still.
Well, the government wasn't...
Well, who was the party? I mean, was it somebody appearing for the trust?
Yes. The trust argument was that after the lapse of the ordinance, the thing done during the life of the trust ordinance do not stand abated, but this remain alive even after the lapse of the ordinance, so the suit has been filed by the competent legal person.
Yeah.
And that's, I mean, one can understand the argument that it's a rather strange proposition that something just disappears into thin air and all its rights and obligations are enforceable against no one.
Well, let us see, if we may, what happens in the next few months. Nothing happens until the following year on the 2nd of June, that's this having been delivered on the 21st of February. The government brings identical proceedings to the 1997 proceedings, seeking identical...
I'm so sorry, Mr. Kilburn.
Yes.
What is the date of tab 5?
I think it's the 21st of February 1998, from memory.
Thank you.
So on the 2nd of June, some 3 months later, having done nothing, the government brings identical proceedings to the 1997 proceedings, seeking identical relief, changing some of the wording to be consistent with the change of plaintiff. And so, again, if you go to flag B1, you see the plaintiff name changes. Paragraph 1, the trust was a body corporate. The Secretary of Religious Affairs, Government of Pakistan, was the Secretary, constituted under Section 5. Then 2, that under Article 89, the aforesaid ordinance stood lapse on expiry of 4 months from the date of its promulgation. As such, the trust established no longer remained in field. The present suit is therefore being filed by Pakistan, who issued the said ordinance. And then if you jump to 6, the party now, of course, being the government, entered into an agreement dated the 10th of September at Islamabad. 7, that is to be effective as from the date the defendant receives, again, the advance lease payment from the trust and submits the requisite performance bond in the terms of the agreement. But as per Clause 2, and you can see it's a scissors and paste job, the plaintiff trust was required to pay a lump sum. 9, that the payment of the above-mentioned advance by the plaintiff, i.e. the GOP, not the plaintiff trust in this case, But if you jump to 11, it's perhaps the clearest. Under Clause 4 of the agreement, the defendant was also under an obligation to submit detailed specifications and drawings of the Mecca housing project, but the defendant failed to comply with this fundamental term of the agreement, which tantamounts to a repudiation of the whole agreement, which repudiation was accordingly accepted by the plaintiff. Now, in this case, the plaintiff is the government, in its letter of the 19th of January 1997, and that on account of the repudiation of the agreement, the same is no longer binding on the plaintiff, the government, and the defendant is not entitled to raise any claim. And in 14, that in January 1997, it refers to the trust instituting a suit, was, however, dismissed by the order of the 21st of February, and it sets out the grounds, and then over the page, the learned civil court observed, however, that liabilities and duties against the defendant can be agitated by the government of Pakistan, that the cause of action accrued to the plaintiff against the defendant as Islamabad, firstly, when the defendant, the government, entered into the agreement, and thereafter when it defaulted in fulfilling the preconditions of the agreement, and the same was repudiated, and finally in January 1997, when it refused to treat the agreement as repudiated. And finally, 16, the agreement was entered into between the parties at Islamabad. Cause of action also accrued to the plaintiff against the defendant at Islamabad. Therefore, this learned court has jurisdiction to entertain and try this suit.
The defendant is actually Dallah, isn't it?
Sorry, the defendant,
Yes, I think that's certainly, you're quite right that paragraph 15 refers to the plaintiff.
Yes.
Which is the government.
Yeah.
Meanwhile, what had happened to this? This was all still part of the Section 34 proceedings, was it? Or at
the
any
early
rate, it
proceedings
was,
are completely lapsed,
including the application.
as far as I'm aware, and then started again in 1990.
Right.
I'm not going to trouble you with this.
Well, they lapse because they're irrelevant once there's no
Exactly.
trust.
Yeah.
Anyway, you say this is a clear and unequivocal representation on the part of the government that it was or had by now become a party to the agreement.
Indeed,
right?
and it's verified, again, by the same gentleman who verified the facts in the previous.
Yeah.
Going back to paragraph 6, Mr.
Yes.
Justice Aikens said that wasn't an admission that the government was a party, because if you have to read it as a whole, it says the parties entered into an agreement at Islamabad, and therefore is purely descriptive of the trust and Dallah.
I think what Mr. Justice Aikens was saying was that was in order to found jurisdiction, that they referred to Islamabad. One has to accept that it's a bad scissors and paste job, because sometimes the old words are in. But the fact is, the underlying point about it in our submission is in order to found the cause of action, they had to rely on the letter, because the letter was the acceptance of the repudiation, which then entitles them to say there's no agreement, and then entitles them to seek a declaration to that effect and an injunction.
It's the whole basis of this cause of action is a thesis derived from the judgment in the first set of proceedings to the effect that the government of Pakistan can agitate liabilities and duties against the defendant that were the trust. It's not saying we were originally a party. It's proposing some sort of principle of particular succession.
Well, with respect, if the wording of the earlier proceedings, where the trust was stated to be a party, is reproduced virtually verbatim in this, and somebody verifies the first proceedings, saying it was the trust that's effectively sent the letter, and then comes along a year later and says it was the government that sends the letter, it must, in our submission, at the very least, undermine the reliance upon what was said in the earlier proceedings. Whatever the reason for him doing it, the fact is he now has to say that the letter was accepted, the repudiation was accepted by the government.
Well, it might undermine what he says in these proceedings. I mean, just because they're inconsistent doesn't mean to say the first one's wrong. As you yourself say, the second set of proceedings are pretty rough pleading, with references to the trust, the plaintiff trust, and then the explanation as to how they're actually proposing to put the case in the quotation from the judge, I would have thought.
Well, my lord, I mean, of course I accept your lordship's argument, but at the same time you have, and you have the verification, I haven't taken you to it, at flag 3, and also I think the main one, yes, flag 3.
Flag 3 in
B3,
in B.
so it's the first number 1, the fact stated in the accompanying application, and those details in the plaint are true and correct to the best of my knowledge and belief.
Well, which application is that referring
It's
to?
the second one.
Is it referring to tab 2?
It's referring to...
Tab
yes,
one.
because it's referring to the Islamic Republic of Pakistan against Dallah.
Yes, because tab 2 is something that the judge refers to as casting light on what we've just been looking at in the second set of proceedings, isn't it? Because
Yes, and I mean,
here we are just a short time later, the government really asking for an injunction on the basis that they weren't a party to the agreement at all.
But what if you look at flag 2, clause 4,
Yes.
what it says is, on account of the repudiation of the agreement, the respondent is not entitled to claim any right against the applicant under the aforesaid agreement or represent or hold out that the applicant has any contractual relationship with it. Well, if it was never a party, why, when asked rhetorically, does it need that? Why does the government need to... I mean, I take Lord Mance's point, obviously, but when asked, why does the government need to go back to the court if the government is not a party and to bring these proceedings? And the answer in our submission is quite simple, and that is, which we'll see in a moment, 3 days before proceedings were started under the ICC and were served on the government. And the government, when it made this initial application in 1998, did not tell the court of the request for arbitration, which it had been served upon it. And so one has to look at it in the round. It's not simply that the court says, you've got the wrong party, try again. One's got to look behind that to find out why they were doing it. Because if they're right and there is no trust, there's no need, not only is there no need to write the letter, there's no need to bring the proceedings. Because by then they knew that the ordinance had not been promulgated on any view. Because the judge, it had been argued in court. So by 1998 there cannot possibly have been any confusion. And all this comes back in our submission.
So they might actually be able to say, if they wanted to, that you were stopped from denying, this is looking at it in common law terms, you were stopped from denying that the government of Pakistan was a party because they relied upon your commencement of arbitration to commence these counter proceedings. But that's a rather fanciful idea. They certainly don't want to say that, and you haven't said that they are stopped from denying that they are parties by reference to anything you did in reliance on these proceedings. That's the one thing that hasn't been alleged in this case.
Yeah. Well, if you look at I was going to take you, because I think Lord Hope was asking earlier, if you go to flag 4, you'll see where the information that I put you comes from. And this is an application by Dallah under Section 3 of the 1937 Act.
What's the date of this?
This is...
Well, it has June 1998
June 1998. So it's in the...
So this is the next lot?
This is lot 2. There were several. You'll be pleased to know I'm not taking to all the proceedings, but there was a 1997, 2 1998, and a 1999 set, which went on and on. But I'm really concentrating on the first 2. And this refers to a suit which is pending. This is my client's, where the respondent plaintiff is alleged that the agreement entered into between the trust stood repudiated according to the default. As a consequential relief, a permanent injunction has been sought by the plaintiff to restrain the defendant from claiming any rights under the contract. notice of the court by fax was received by the defendant directing appearance. So it was an application which was made ex parte, or without notice, on June the 13th. The present application is being filed without any loss of time, without taking any step in the proceedings. The proceedings in the present suit are liable to be stayed for facts contained in the application, the provisions of Section 3 of the Arbitration Act. Then it refers to the arbitration clause and Article 25 of the contract, that in pursuance of the agreement has already filed against the plaintiff a memorandum claim in the International Court of Arbitration, petitioner's letter and letter of that court dated the 25th of May. The ICC issued a notice process to the present respondent plaintiff, that's the government, on the 29th of May 1998, along with the annexes detailed in the letter, which was received by the plaintiff on the same day, and which had been acknowledged by the plaintiff in its letter referred to herein, that the plaintiff, on receipt of the notice, hastily proceeded to file the present suit in this honourable court, along with an application for interim relief, without disclosing to the court about the proceedings filed by the defendant petitioner in the International Court of the ICC, of which notice had been received by the plaintiff prior to the filing of the suit. And then it talks about mala fides, which I won't go on with. And the other point that the...
Hang on, this is all in the context of Dallah's request for arbitration against the ministry, is it?
Yes.
Where do we see that?
Well, Dallah, what had happened is Dallah had already, just before these proceedings had launched, Dallah had commenced proceedings against the government in the ICC.
Yes. Where do we see that?
That's clear. I thought...
Where do we see the proceeding?
Oh, well, that's in a different bundle. I'm coming to that in a moment.
Oh, right.
I've just otherwise
give me
I'd
the
be moving
reference?
from bundle to bundle.
Right.
But this indicates...
Anyway, so they make an application, your clients make an application for arbitration to the ICC against the government.
Against the
Is that
government.
right?
That is served on the government. 2 days later, the government make this application to the court without telling the court.
And you say that they accept that here, do they? Or at least they accept that they're a party, do they? In the document now I'm looking at. Tab.
Well, in the document that you are looking at, there is reference to the letter, to the request for arbitration.
Yeah.
The request for arbitration is clearly made against the government and not against the trust.
Yeah.
Yeah.
And what I'm saying is the sequence is application, following the letter of the 26th of January, which I'll come to in a second, where we had told the government in response to their letter of the 19th of January, we would issue proceedings. We did issue proceedings at the ICC against the government. It was served on the government. When the government received it, they went off to the court, having done nothing in the last 3 months, and started the proceedings all over again. But they didn't mention, because it was an ex parte application, that in the interim they had actually received arbitration proceedings against them. We then come back in on notice and raise this point, and that's where this comes. And the point being, again, that in order to fund these proceedings, because the proceedings could not, there wasn't a cause of action without that the letter was integral, and the contents of the letter were integral to the plaint in both the first 1997 and the second 1998. And what this does at the very least is that it casts doubt on what was going through the mind of Mr. Lutfer Mufti in 1997, which the judge places so much reliance upon. Because here's the same gentleman now in a different scenario saying something completely different. And we say, quite realistically, you cannot place all this weight on what happened in 1997. You have to look at it in the round. And it's not, just as my learned friend, without any evidence, tries to say, as I think Lord Clark or maybe Lord Mance had said, well, maybe Mr. Lutfer Mufti's made a mistake. The same you can also say, but here's a government, in effect, using legal action tactically to ensure bolt and braces, that now having made sure that the trust isn't a party, it wants to make quite sure that Dallah, who after all are chasing them, and responded subsequently in the letter to the government to get on with it, don't try and make life difficult for the government. And the easiest way is really a declaration of non-justiciability or whatever, to say that's the end of it. And the Pakistan courts would then, they hope, say that there wasn't a contract, and the government would then be clear of it. Yeah. So we say, therefore, that the 1997 proceedings cannot be as cast iron, as Mr. Justice Aiken said. You have to, under the French test, look at the whole scenario. You can't stop in 1997. You will have to go on to 1998.
Well,
there'll come a point where you stop.
Yes, well, he didn't stop at 1997 at all.
No, he didn't, and I'll explain what he said. Of course, the 1998 proceedings didn't proceed further. But there are 2 points on that. One is, what one is looking at is not the legal consequence of these proceedings, but the conduct in the proceedings as evidence of behaviour of the government, from which you can determine under French law a subjective intention. So what legally happened, to one sense, is irrelevant, because what you're looking at is the conduct of the parties. And that's why the inconsistent affidavit on the inconsistent pleadings in our submission is a relevant factor. At the very least, it undermines the reliability of the earlier affidavit upon which Mr. Justice Aikens then was relied. And I was just going to take you to the passage which deals with the letter of the 26th of the 26th of January, which I told Lord Hope I would come to.
Yes.
Just momentarily lost it. I think it's... Can you find it? Okay, I may have a reference to it. Just forgive me 1 moment, I think. It's EB7, according to my note.
EB...
Yeah, it's EB7.
Tab 7.
And the reference...
You're right.
The reference is page 37, that's all we've got. This is a memorandum of essential facts in the 1998 proceedings.
Oh, yes, it's at the bottom of the page.
The bottom of the page.
Yeah.
The defendant, through its advocates, it must have been a solicitor's letter,
Yes.
dated the 26th of January, promptly responded with a denial of all the allegations contained in the aforesaid letter of the plaintiff, and called upon the plaintiff, that would be the government, to withdraw the same within 8 days of receipt of the said letter of January the 26th, and to proceed diligently and in good faith in conjunction with the defendant appellant towards implementation of the agreement and fulfilment of the obligations thereunder. It was specifically mentioned that if the plaintiff respondent failed to comply with the aforesaid requisitions, the defendant appellant shall be left with no option but to enforce all the rights and remedies available to it under the agreement and law, which would include reference to arbitration under the ICC Paris without any further notice. It's important to note that before the aforementioned letter of January 19, 1997, the ordinance had lapsed by operation of law, and as a result thereof, AHT and all the office bearers, including the Secretary, ceased to hold office.
Where's the letter of the 26th of January?
Well, we don't have it, that's
well,
right.
You said it was referred to the government, but there's nothing to demonstrate that that's the case.
Well,
it could just as well have been written under the misapprehension, which I think you accept your clients had, that the trust continued to exist.
Well, except it says that it refers to the plaintiff, and these are proceedings...
Well, you may be making the same blurring of identity of the plaintiff. Since at this point, these are proceedings where the government is asserting that it has succeeded to the trust. One can't deduce very much from the reference to the plaintiff, can one?
Well, say this, that the threat was to bring proceedings in the ICC against them, and the proceedings were brought against the government, not the trust.
Well, how long later? 18 months.
No.
Proceedings in the ICC
Oh,
were
yes,
begun.
sorry, in 1997, the ICC in May
98.
May 1998.
Yes, so 15 months later or so, or 16 months later.
Well, where do we go from here?
Well, I'm just going to.
Ought we to note that at tab 6, the actual decision in the second set of proceedings was that the government of Pakistan was wrong to allege that it was the successor or had become parties to the agreement?
What happened, my lord, is that there was then an appeal. My clients lost initially. They then appealed.
Where is the judgment where they lost?
Well, it's tab 6.
Tab 6.
Tab 6.
It's really the foot of page 32 and the top of 33.
Yes.
And I can take you to it in detail, but I wasn't.
Well, I think it is worth just.
Indeed,
just noting.
I'm only anxious not to detain you too long on the facts. If one goes back to paragraph 3.
I'm sorry to take you back a little bit, but
Yes, Lord.
In tab 5 is the response to the application for a stay, is that right?
Yes.
And they seem to be taking 2 points. Is this right? The first point they take, page 27, 28, there is no valid and effective agreement between the parties, appears to be on the basis that the agreement never came into effect because Dallah never got round to setting up the finance.
Well, yes, because by now an application had been made, my clients now coming in on notice to stay the proceedings. Remember, unlike the earlier application to stay, by the time we get to 1998, there were arbitration proceedings on foot.
Yes, I'm not.
No, your
I'm not challenging that.
Right.
I'm just looking at the points that appear to be made on behalf of Pakistan. Point number 1, is this right? Paragraph 3 of this reply is, well, there's no question of a stay because there never was an effective agreement in the first place. And the reason there wasn't an effective agreement in the first place was because if you look at the agreement, it says it'll only come into effect when certain things are done, and Dallah didn't do them.
Yes.
So that's the end of the story. They do then seem to be saying that there is a difference between the Republic of Pakistan and the Ministry of Religious Affairs. Is that right?
That was a point that was taken as to that we'd sued the wrong party before the tribunal, and the tribunal dismissed that. But that was an issue they
sued the wrong party, though,
well,
in the sense that it shouldn't have been the Ministry of Religious Affairs, it should have been the Islamic Republic of Pakistan.
Yes. But in fact, the phrase that we used for the title was felt to be correct.
Yeah. So far, let's just say up to tab 5, the point isn't taken that the only party to the agreement is Dallah.
Is Dallah?
Is the trust.
Is the trust.
I beg your pardon.
Yes. This is the point. In these proceedings, what happens again is, as Lord Saville has said, there is nothing which says that the government is not a party and the trust is always all material times was the party. If the government is coming in, bringing these proceedings, and what you will see, what happens is that my clients then bring this stay, they respond in this way. The judge dismisses my client's application. When my clients seek to appeal, The government then, presumably realising the problem they're getting themselves into, withdraw the application on the basis of, quote unquote, a formal defect.
Right. Well, I was trying to catch up with you, I think. So I'm right, am I? As far as tab 5 is concerned, it's the government of Pakistan takes 2 points. One, an agreement never came into effect.
Yes.
And it never came into effect because Dallah didn't get round to providing the finance. Is that right? That's point number 1. So you can forget about a stay because there never was an enforceable agreement. Never came into effect.
Indeed, I think it actually, in fairness, goes further because it refers to clause 2, 3 and 4. So I think it would cover the plans, which was part of the repudiation matter as well.
I'm sorry, I didn't follow that.
It refers at the top, just to make sure it's not unclear.
I was looking at page 28.
Yes, but at the top, your Lordship says not become effective on account of the defendant to fulfil the prerequisites. I think I may have misheard you. Your Lordship said the financing. It in fact goes a bit further than that.
I'm sorry, that was a shorthand. There were various other bits and pieces that it said, going back to the letter of the 19th of January, that Dallah had not done, as a result of which the agreement was ineffective. That's point 1.
Yes.
Point 2 is you brought arbitration proceedings against the wrong party.
Yes.
Because you brought them against the Ministry of Religious Affairs, should have been against the Islamic Republic of Pakistan, as I understand it.
Yes.
Right. So, I'm sorry to be so slow about this.
No.
So, what happens next? There's some hearing on this, or what?
Well, insofar as we can tell, there is a hearing because there's then a judgment at flag 6. I don't know whether your Lordship, rather than for speed, would prefer just to read it yourself, or I can read it out. I'm in your hands. I can start, if you want, at paragraph 3, but you may just want to glance down the earlier bit, which sets out the history. And really, perhaps the last sentence of the first, or the introductory paragraph. Through the present suit, the plaintiff has sought declaration to the effect that the agreement has not become effective and stood repudiated on account of the non-fulfilment of prerequisite, and that the defendant is not entitled to claim any right under the said agreement against Pakistan. Defendant filed application under Section 3, read with Section 34 of the Arbitration Act seeking a stay, on the ground that under Clause 23 of the agreement, the dispute arising out of the agreement is liable to be settled by arbitration by the ICC in Paris, and under Clause 25, trust has waived objections to citing of the venue. Further submitted, the defendant already filed his claim in the ICC, and notice to this effect has been served on the plaintiff, i.e. the government. The plaintiff respondent contested the application. It was submitted there exists no valid and effective agreement between the parties, and that the proceedings initiated by the defendant in the ICC are against the Ministry of Religious Affairs and not against the government of Pakistan. It was further submitted that process, if any, was issued in the name of Ministry of Religious Affairs and not the present plaintiff. Just pausing that, to add to that, when we come to look at what happened in the ICC, you will see that one of the points the tribunal picked up on was that, in the initial stages, really Lord Savile's point, it wasn't actually stated that the arbitration should not be proceeded against the government. All that was served on the ICC was the injunction asking the ICC not to proceed with the arbitration.
Do we need more than the summary in paragraph 46 of the agreed statement of facts?
My Lord, your Lordship may be right. I'm conscious that I just lost my... Yes, I think that probably is sufficient.
It's all at the top of page 33.
Yes, it is really. There's about 6 lines down from the top of page 3. It's a critical bit.
Yeah.
And then your clients appealed, and then the proceedings were discontinued by the government of Pakistan.
On the basis of a formal defect.
Whatever that might
Whatever
be.
that means, exactly. My Lord,
Well, I'm just wondering where we go from here. Do we need any more of this?
I don't think
this
so, my
bundle?
Lord. My learned friend will take you to the 1999 proceedings. I don't propose to do so. I just wish to make this comment, that in the context of 99 proceedings, and obviously in the context of any judgment in relation to the facts, what this court is looking at is how the facts pan out according to French law. The judge in Pakistan will, of course, be determining it according to Pakistan law. Just to ask you to bear that in mind, if and when my learned friend takes you to any further documents in relation to the 1999 proceedings.
What issues will be determined under
Well,
Pakistan law?
My learned friend will be taking you to a judgment in the 1999 proceedings,
Yes, correct.
in which various findings were made as
Yes.
to who was and who wasn't a party.
Yes, I
The only
see.
point
So
I'm
it's-
making is
yeah.
that
There's no issue. It's not suggested they give rise to an issue of estoppel.
No.
And indeed, it's rather odd that the judge went as far as he did in making apparent findings in the 1999 proceedings, since the matter wasn't there for trial of those issues.
Yes. The position then went up to the Supreme Court. I understand, I should have mentioned this to my learned friend, that in fact the petition to the Supreme Court has now been dismissed. Not quite sure whether the position is now, but that's further down the line. It's simply just to make the record correct. What I think is just relevant before I go to the judgment and the award is just to take you to a few documents in relation to the arbitration, which you will find in Bundle D. You can put away, for the moment at any event, the Pakistan proceedings, perhaps not the easiest to follow.
So we go to bundle D.
And the only real relevance of the Pakistan proceedings is that they, in obviously just dating this judgment, were relied upon as showing intention. In our view, they show the contradictory behaviour of the Pakistan government in relation to this matter, and their desire to extricate themselves from any vestigial remaining allegations that may be made against the government. Now, on D, if you go please to 4,
B was that?
D for dog. Sorry.
This is 5th of June 1998.
It is indeed. And this is from Walter Martineau Salem acting for the government. Your attention is invited to your notice of the 29th of May in respect of the above matter, where our client is required to file its answer to the request for arbitration within 30 days. We wish to bring to your notice that our client has filed legal proceedings in Pakistan, which are pending in the Court of Civil Judge First Class, Islamabad, and are fixed for hearing on the 13th of June 1998. The learned judge has been pleased to grant an interim injunction pertaining to the dispute. A copy of the court's order is attached for your information. And then draw attention to Section 35 of the Arbitration Act. No reference or award shall be rendered invalid by reason only of the commencement of legal proceedings on the subject matter of the reference, but when legal proceedings on the whole of the subject matter of the reference has been commenced between all parties to the reference, notice thereof has been given to the arbitrator or umpire, all further proceedings in a pending reference shall, unless a stay of proceedings is granted under Section 34, be invalid. In this section, the expression parties to the reference, including any person claiming under any of the parties and litigating under the same title. And the point that perhaps is obvious and which the tribunal made from this is, of course, this is the first response to the request. It nowhere says that the respondent is not a party to the agreement. What it says is we now have an injunction obtained, as it was, without notice from the government. Please do not go on with the arbitration. The next document is the next page, which is the 15th of August. The same lawyers also to the ICC, referring to 2 further notices. We wish to bring your kind notice that our client has already declined to submit to the jurisdiction of the International Court of Arbitration. It may also be brought into your kind notice that our client does not and shall not submit to the jurisdiction of the ICC for inter alia the following reasons. There's no contract or arbitration agreement between our client and Dallah. The contract and arbitration agreement referred to by the claimant were entered into by the claimant and the trust. The trust has already ceased to exist after expiry of the ordinance. Clause 27 of the contract provides that the trust may assign or transfer its rights and obligations to the government without the prior consent in writing of Dallah. The trust never assigned or transferred its rights and obligations. The contract was entered into and executed in Pakistan, and under well-established principles of law, it's governed by the laws of Pakistan. Hence, the Arbitration Act is not applicable. Any award passed by the ICC will not be enforceable, being against the public policy and laws of Pakistan. Under Pakistan law, the application of the Protocol on Arbitration Clauses is limited to contracts which are considered as commercial under the law in force in Pakistan. The contract in question was entered into for religious purposes, to provide housing facilities to Pakistan pilgrims. Therefore, the laws of Pakistan don't recognise the Protocol on Arbitration Clauses. Our client never agreed to make a submission to arbitration, and unilateral submission to arbitration by the claimant alone doesn't constitute actual submission under the laws in force in Pakistan. The contract provides for leasing of accommodation to the trust for a period of 99 years, which is not permissible under Saudi law, so the contract is void. And the contract was to become fully effective and operative, subject to arranging of finances within 30 days and submission of detailed contracts and specifications. Since none of these conditions was fulfilled by the claimant, the contract and the arbitration agreement never became effective or operative. Kindly take into account the above factors and reflect the claim as the same is not maintainable. However, this letter shall not in any way or manner be deemed to constitute on the part of our client a submission or acquiescence to the proceedings, nor have we any instructions from our client authorising us to join the proceedings or to represent it in any proceedings. And I think that, for present purposes, as far as I need to take you. Now, what I would like to do now, with your Lordship's permission, is to take you, with that outline of the facts, to the tribunal's reasoning and the judge's reasoning. But before I do so, can I just make a few points? First of all, you will have seen from my learned friend's case that I have perhaps been roundly criticised for saying different things at different stages of the proceedings. My Lord, forensically, one often refines and changes one's submissions, and I hope what I say today will be better and more persuasive than my submissions in the past. Let me make 6 brief points before I take you to the documents. First, before the tribunal, the parties argued respectively for Saudi law and Pakistan law. It was the tribunal which decided, as it was entitled to do as a tribunal with a French seat, to apply transnational law. And it ultimately agreed in relation to the main agreement, the arbitration agreement being separable, that the main agreement could be determined according to Saudi law. So you have perhaps a case which is not uncommon but a little unusual, where the arbitration agreement is determined by a different law from the main agreement. The second point is that the relevant article under the New York Convention provides, in this case, that the relevant law is the law in the country where the award was made. I conceded, as it appears to be the prevailing view and was supported amongst others by Albert Vandenberg in his treatise, that this means the substantive law rather than the conflicts of rules law in France.
To accept that point, we don't need to go into the conflict.
Well, my Lord, I in my submission, that appears to be correct. And I have to raise it because my learned friend says, and makes a strong argument to say that the tribunal didn't apply the same test because the tribunal applied transnational law as opposed to French law. I therefore have to make good the point that in our submission and on the evidence and on the law, transnational law is a part of French law.
it is not a foreign law in the sense where you have a choice of laws. It is a law which a French tribunal or French court sitting in France determining an arbitration clause would apply. And I can make that good if you have before you bundle B and B1.
But I thought you said before it didn't matter.
My lord, I say it doesn't matter, but my learned friend says it does matter, because my learned friend says, sorry, my bundle's just collapsed. My learned friend says that when you are, one of my arguments before your lordships is what we have here is a tribunal applying the same agreed law to effectively the same facts as the English court did, coming to different conclusions. What my learned friend will say to you is, oh, no, that's not the case. You have a tribunal applying transnational law. That's not the same as French law. I can reserve it for reply, but in our submission, it's quite clear when one looks at the authorities that transnational law is a part of French law, and it's not a wrong one of French law. And that was why I was going to make that good now. I can leave it till reply if your lordship would prefer. I can give you the references. Would that be a shortcut?
Well, I was just wondering very, very briefly. I mean, is this simply because of the nature of the arbitration agreement? It's an international arbitration agreement.
Yes.
And it's because of that, you say, that it's not a choice of law point? Is that
well,
as simple as that?
It's because of that, and it's because of what French law says. Because it's what is said is that because I've agreed that the law by which this arbitration clause has to be determined is French law. When the tribunal were looking at it, they were determining the issue, albeit that common intention is the same for both, by a different law. And therefore, you can't say that they were carrying out the same exercise.
The way it's put in your case at page 23 rather suggests that it is an option. You see little 4 on page 23. And this is from the joint memorandum, I think you're quoting.
Yeah.
Do you see this at page 23, little 4?
Yes.
The existence, validity and effectiveness of the agreement in international arbitration need not be assessed on the basis of national law. It is open to find that the arbitration agreement is governed by transnational law. I thought that the position we'd reached was that it was governed by French law.
It is governed by French law, but French law applies transnational law. It's not French law deciding whether it should apply English law or French law. It's French law as part of its own law will, in such circumstances, apply transnational law.
Well, what is that? Distinguish that from a conflict of laws rule. When does it apply transnational law?
Well, when it is determining, or in a seat in France, the law to be applied where there isn't another choice of law, where it's French law, for the purposes of determining, in this sort of case, anything relating to the arbitration clause. I think it probably is just quicker if I take you to a couple of documents to support it. The first is, I think, is cited in, the first is cited from the joint report, so joint memoranda, I need to take you to that. If I take you to B1, for example.
Is this in bundle B?
Bundle B1. I've just lost my bundle. No, I want mine. At 9. Oh no, sorry, it's my fault. It's B. It's B. I need to take you at 9. I think. Forgive me 1 second. Was it B? No, I've been given the wrong folder. It is B1. It's B1.
and it's flag 9.
Flag 9.
A B1, there's a file called B1, which is different from B.
Sorry, my bundle fell apart and I had it marked up. I've now got it back. Thank you. It's shortened things.
This is Fouchard, is it?
It is Fouchard, yes. If you start at page 67, application of the substantive rules method by courts reviewing arbitral awards. Generally speaking, the circumstances in which the French courts will examine the validity of an arbitration agreement are fairly limited as a result of the competence principle and the limited grounds on which an award can be set aside or refused of enforcement. Issue will arise where parties petition for an award to be set aside or enforced, and where it is alleged that either the award was made in the absence of an agreement on the basis of an arbitration agreement was void or had expired, or that the arbitral tribunal declined jurisdiction after wrongly deciding that an arbitration agreement was non-existent or invalid. It was in this context that the courts held that the existence and effectiveness of the arbitration agreement should only be scrutinised in the light of the requirements of international public policy, to use the expression coined by the Paris Courts of Appeals. We've seen that the criticism levelled against these decisions was prompted by the court's use of unfortunate terminology regarding the arbitration agreement's own effectiveness, and was particularly concerned with the practical and theoretical impossibility of basing the validity of the contract on no law at all. The criticism is unfounded, however. In French case law, the intention is not to remove the arbitration agreement from all forms of control. It is instead to restrict such control to a review of the arbitration agreement in the light of the French conception of fundamental requirements of justice in international commerce, referred to by the French courts as international public policy. Although the goal is not to avoid the application of the law otherwise competent, the expression international public policy is well chosen where the decision to be taken is whether or not a dispute is arbitrable, an issue falling within the scope of Article...
I'm sorry to interrupt. Now, we're looking here. This is a passage about what the French courts will do if the tribunal decision is tested. I thought we were on the question of what the tribunal should do.
The tribunal was sitting in...
I understand that, but this doesn't address that question, at any rate, not expressly.
Yes, you were seeking to make good the point that this isn't a French conflict rule,
yes,
but is a part of French law. Although I'm not myself sure that's the right question, because the real question is whether in the enforcing court it should be regarded as a conflict rule, because within France they wouldn't normally need to decide the question whether the application of transnational law is a conflict rule or simply part of French law.
But the prior question, with respect, that is right. The question that I believe is said against me is we say that for the purpose of enforcement you have to apply what has been agreed, you have to apply French substantive law. Mm-hmm. But as part of French substantive law includes the application of transnational law, there is no, what we're saying is that there is no distinction. What is said against me is that transnational law is not part of French substantive law.
I mean, on the face of it, it can't be. I mean, because by definition, if you are referring to something other than French law, if you're referring to transnational law, you are referring to something outside French law. That's what passes me. I can see that French law might have very general, internationally based principles in it. But as soon as you say there comes a point where a French tribunal would say, sorry, we're not going to apply the Code Napoleon or whatever, we're going to apply these general principles which we derive from international authority or law, that is a conflicts rule, isn't it, by definition? The French court has decided to...
First of all, to make this good, if one looks at the code, one will see that there is provision for this in the French code.
Also, I was taking you, first of all...
You mean that the French code provides
Yes.
for the application of transnational principles in certain circumstances?
It doesn't use the phrase transnational principles. It uses the phrase that I've just been reading to you, which is equated.
What international public policy?
Well, let me take you...
But this is on a different point.
But equally, if it said the court shall apply German law,
Yes.
without saying this is a conflict rule, it wouldn't stop the English court saying, well, that's a conflict rule.
Right.
Well, that may well be the case, but can I just take you, before I move on to this, and it may be I wait till reply to deal with it further, but if I can just take you to flag 6, which is the case of Dallah, which is very short.
Flag 6 in the same bundle.
Same bundle, yes. And this perhaps sums it up. I was just giving you a sort of wider synopsis, but perhaps this is quicker. And the second page, whereas by virtue of the substantive ruling of the international law of arbitration, the arbitration clause is legally independent of the main contract.
I'm sorry, I'm not with you. Flag?
Page 45, flag 6.
Page 45.
It's the second page of a case called Dallah.
Sorry, tab 6 of B1.
Yes.
It's the very last page.
It's page 4.
Yes, of course.
B1, yes.
It's page
Sorry about that. Yes, I'm with you.
Because it's so short, that was why I was going to read it, but perhaps you might read, because it does refer to Dallah. The arbitration clause is legally independent of the main contract, containing same directly or by reference thereto, and that its existence and effectiveness are appraised, subject to the mandatory rules of French law and international public policy, based on the joint agreement of the parties, without it being necessary to refer to a state law, whereas in this case, the Court of Appeal legally justified its decision by establishing the existence of the arbitration clause without regard to the Libyan law featuring in the contract. I don't think you need any more, but a very short extract, but if you just go back, if you would bear with me to just 9, because it's...
Sorry, what do we get from this?
Well, as Fouchard says, at 9, reduced to its simplest form, the rule laid down in the Dallah case is that the concept of an arbitration agreement and that of an agreement that was void have a meaning of their own and are not subject to any choice of law rule, which may point to the application of national laws. The arbitration agreement is not a contract without a governing law, but a contract without a choice of law.
But that doesn't take the matter any further, does it?
Well, my lord, I take your lordship's point, but...
It's a very bad translation now.
It's not very clear, I accept that.
But we're looking, Julie, we're looking at section 103 and the phrase which we find in our statute, which is reproducing the convention, isn't it?
Yes.
And it's the law of the country where the award was made.
Yes.
And your proposition is, well, the law of the country doesn't mean just French domestic law. Is that what it comes to?
Well, my proposition is the law of the country is how the French courts would determine this issue.
Well, that would include all their conflicts principles, which I thought you had specifically accepted. Below it didn't.
Well, one doesn't need to go so far as to the conflicts principles, because what I'm suggesting, in the light of this, that it's, and if one looks at Article 1496 of the Code, it's part of French law in any event. It's as if we're looking at concepts of just international justice, because transnational law at the end of the day is based on justice. And it's not a particular set of rules in the sense of an English law or French law or Italian law. It is a way in which the French courts, sitting in France, would determine in their own country, without going to another country, would determine in their own country how the arbitration clause works.
So you're saying, if I understand you correctly, that it's got nothing to do with conflicts of law. It's not a test to apply the law of a particular country or countries. It's got nothing to do with that sort of conflict question. It is simply part of French law when dealing with an international arbitration.
Well, because the seat was France, it's in this case, because there was no choice of law, the default under the New York Convention is France. Now, that was my concession. I can, of course, with your Lordship's permission, go back on that concession. But that was the then thinking from Albert Vandenberg, and we both at the time agreed in response to Mr. Justice Aikins that was the position. Of course, it's open to your Lordships to take a different view. But if one looks at, I'm just getting the French.
I wondered whether Fouchard, I'm sorry to interrupt you as you're searching, but Fouchard does put it about 4 lines from the foot of the page in tab 9, page 68. Just in a few words, the principles considered by French law to be fundamental in an international context. Is that really what it comes to? It's a very succinct proposition. But at the moment, I'm not sure what this adds to what was in the memorandum as to the test.
It may not add very much. It was simply that I was meeting a point which has been dealt with at considerable length by a learned friend, who was saying, well, the tribunal and Mr. Justice Aiken were dealing with different laws. At the end of the day, it may not matter, because the test is the same.
Right.
And so whether you call it transnational law or the law was
And it's more or less agreed, as I understood it, it was more or less agreed what the relevant test in French
indeed,
law was.
Indeed.
And I thought the next step was to look at the arbitration award and see what principles the arbitration tribunal applied under the heading of transnational principles, and see if they're the same.
Indeed,
if they're the same, then they're the same. If they're different, obviously they're different.
I mean, I thought the strength of the argument was that they'd misdirected themselves because they applied the wrong test.
Well, it's only because it was raised in my learned friend's case that I felt I had to deal with it.
Yes.
My lord, that is absolutely right, and that's the next point that I'm going to come to. And I would like you, just if you would bear with me, to keep up B, and just to take you to a couple of bits of the transcript of the evidence of French law.
So we've got which of the volumes?
So we want B5.
No, is it B1 or B?
No, B this time. At 91. It may just be useful to your Lordships to see it.
Is this B for butter or
B for butter, yes.
5.
volume 5 or volume 1 or what?
B for butter, no, B, volume, tab 5.
Oh, tab, I
B
see.
without a 1.
No, tab B1, tab 5. It's just
No, B tab 5. B1 is the authorities.
Bravo 5.
B5
Bravo
is part of the evidence. Is that right?
This is the transcript.
Yes, copy. Right.
And at page 91 at 18, or perhaps start the question, Mr. Lander, Mr. Vattier, a question which may be too general, but I'd like to see whether you can give a short answer to it. So you've read the first partial award. Are you able to comment whether, in your view, the approach that the tribunal took on this question is the same approach that would be taken as a matter of French law? We're then asked to look at it. If I've understood the award, in section 7 there is the test of acceptance of arbitration. I'm in general in agreement with the issue raised in point 7, but I find the grid, which I understand is is in fact a mistranslation. It means the legal criteria. This test is not accurate enough. Furthermore, a French judge might draw different conclusions from those that were reached by the arbitration panel. On the other hand, the principles adopted were in general the principles that might be adopted in French law, but they're too general. The tribunal did not deal with each of the specific points. Let me give several examples. And then he goes on to give an example, the facts, and Mr. Justice Aiken says, the witness, please finish this example. I think we cannot go through this because it's not the witness's job to do it, it's my job. And then if you go to where I put this to Mr. Vattier, I've just lost my record. I put to Mr. Vattier, when I ask him a question, the actual paragraph from
I'm sorry, I've not put in the reference. Yes, it's page 94. And I ask him, Mr. Vertier, could you please read paragraph 6 of the award to yourself? And your lordships might like just to do the same, which is at 5E at page 414.
I.E.
Yes. This is in the core bundle. And it's paragraph 6, which says, arbitral, whereas judicial case law has widely recognised that in international arbitration, the effects of the arbitration clause may extend to parties that did not actually sign the main contract, but that were directly involved in the negotiation and performance of such contract. Such involvement raising the presumption that the common intention of all parties was that the non-signatory party would be a true party to such contract and would be bound by the arbitration agreement.
Sorry, I didn't pick up which page you were referring to.
Oh, I'm so sorry, Lord Hope. Page 414 of the core bundle.
And the paragraph number in...
5, just to make it complicated, is 5E.
Well, I'm looking at the...
Right at the back of the bundle.
What is the paragraph number in the judgment?
6 is the number.
Paragraph 6.
There are several paragraph 6s in this.
Page 414, the paragraph 6 on that page,
The
isn't it?
paragraph 6 on that.
Internal page 26.
Internal paragraph.
Thank you, that's the thing, yes. Thank you. Yes.
And which paragraph, which page are you on in your cross-examination?
I'm on page 94.
94.
4.
Unfortunately, 4 is missed out of our print. It just comes before 95.
Yeah.
And in fact, the tribunal, you will see, go on to expand upon that. And then when he's read it, is that the correct test as would be applied by a French court by way of common intention in a case or matter such as this? It is the general principle, yes. And then I understand there is a difference here between the weight... So there's two passages there where it is accepted by the expert for the government that the correct test was generally applied. The one other point, while you have that bundle open, if you would just go, because the point that was made earlier about coming in to as a party late in the day, and if you look at Mr. Durin's evidence at page 131, my witness, Mr. Durin, was cross-examined, and Mr. Landau said, I want to move on. Do you have it, my lords? Page 90 internally.
Yes.
I want to move on to the separate topic in your report, which is paragraph 23. That's the notion of, in a sense, a succession question rather than just a purely consent by conduct question. I want to try and understand a bit further the precise doctrine that you're describing, the rule. As far as I understand it, this is a rule that is different from consent by conduct, or is it really the same rule? No, I think it is the same rule. It's the same rule, yes. So what is the consent one is looking for applying this rule? It's the same rule, it's not the same moment. It's the same rule, but it's not the same moment, I see. At a certain point, you enter in and you perform the contract when you become the party to that contract and to the arbitration clause. Does it assume as one of the steps that by conduct you will become a party to the underlying agreement? Yes. You appear to have been a party, exactly as in other cases when the courts say that when a party participated in the negotiation, in the performance and so on, that a party appears to be a party to the contract by this behaviour, and then it is bound by the arbitration clause. Then the arbitrator may decide at the end, for instance, that the contract was null and void. But are you still applying the same test of common intention? Yes.
and the same subjective inquiry that we have already spoken about, yes. So the test you are applying, or the question you are asking of the party in question is, did they subjectively intend to become part of the underlying agreement, to become a successor? Yes. Well, did the subjectivity alone, did they want alone to become a party? I don't think this is the test. As they behaved as being a party, the other side considers they were a party, and the fact that behind the head they were not considering the matter is irrelevant. Yes, so it's the same test in all the cases. Is it the same test? Yes. So you still look at the subjective intention of the party that is behaving that way. As Mr. Vati said very clearly, I think you find a subjective intention through a number of objective factors. Exactly. So you do that for the party that is behaving as a successor, yes. Then you do it for the other party as well to find out a common intention, yes. So that's the evidence on the later.
And here we're looking for, to answer those questions in relation to the underlying contract. When we have an answer in relation to the underlying contract, then we have the same answer in relation to the arbitration agreements, do we? Generates on the facts of this case.
My Lord, in practice, though, it is right that...
I quite understand you can have all kinds of theoretical situations where that wouldn't be so, but in this case, you have a question. The issue is one of common intention in relation to the underlying contract. If you win that, then it would follow you would win the arbitration clause point. If you lost that, it would follow you'd lost the arbitration clause point. Is that correct?
In my submission, it would be enough in this case. It may be said against me.
Oh, we'll come to it. But on your submission, that's correct.
In my submission, in practice in this case, it would be enough.
So we don't have to worry about that. It's generating your case.
Yes.
So we're back to the question of what were the common intentions, what were the subjective intentions of the parties,
yes,
derived from the objective indicia.
And just two more points that are made against me in the my learned friend's case before I take you to the tribunal's reasoning. The more restrictive approach of the English courts to arbitration, whose seat is England, and he refers to certain cases, it is in our submission, of course, irrelevant in the context of enforcement. And this is really in the context of transnational law. Perhaps I didn't take that any further in the light of our discussion. And finally, it's said that the tribunal didn't have the benefit of the same evidence and submissions. Well, of course, I accept it didn't have the benefit of the advocacy of my learned friend, Mr. Landau. But the evidence that was before the tribunal was, in fact, with the exception of two matters, identical. One was the witness statement of Mr. Natby, which was used in the liability hearing, which was produced before Mr. Justice Akins. The other was the judgment in the 1999 proceedings. As far as I'm aware, I'll be correct if I'm wrong, there was no evidence whatsoever produced by the government. That was evidence, I believe, certainly in the case of Mr. Natby's witness statement, which was produced by us.
So the only additional material that the judge had was experts on French law.
And experts on French law.
Yes.
And also, in fairness, there was expert evidence on Pakistan law. But Pakistan law, in the end, really faded away, except the judge dealt with Section 173, and there was an issue as to whether or not it was directory or mandatory for the President to sign the document. And he didn't make a decision in the end on that.
And yes, I see.
Now I'm going to take you, if I may, to the award, and for this, I think...
Is this going to be your point 3 of your 6 points?
I think I've lost numbering. I'm sorry, my lord. The first point was... the first was the Saudi law. The second was my concession in relation to the law being a substantive law. The third point was our discussion about transnational law. The fourth was the evidence, which I've taken you to. The fifth, which I didn't really pursue in the light of what we've been discussing, which was the more restrictive approach of English law to transnational law, because English law doesn't recognise a non-national law for the purposes of an arbitration clause. And the final point was the fact that there wasn't any new evidence. The onus, of course, being on the government of Pakistan to prove its case. Now, I'm going to take you, if I may, to the award and start at page 26 internally, which is really the page 414,
Sorry, what page in terms?
26.
So paragraph 6 we were looking at before, because
Well, I'm
that's
just going
what
to
they were
start,
asked
if I might,
to
with
do.
the paragraph before, simply to say that the control exercised by the state over the trust becomes within that framework an element of evidence of the interest and role of the party and provides the backdrop for understanding the true intentions. Then you have paragraph 6, which we've read. Paragraph 7 expands upon that and divides it up into the various periods, and those are the various periods which the tribunal dealt with.
And the words all stages pick up the point you were making earlier, I think.
I'm sorry, my
The
lord.
words all stages.
Yes,
So
deals with all the
it's from
stages.
start to finish, you
Start
look
to
at the lot.
Now, we're not here concerned with any concept of agency or anything of that kind,
No.
are we?
This is common intention. I'm not going to read it all, my lord. I'm just going to select points because a lot of it we've been through already. But just to summarise, I mean, 8.1 deals with what happened and the introduction, of which you're now familiar. If you go to 8.2, the tribunal makes the point, having explained the overlap, and I'm using this as a neutral word because there isn't, we're not running the alter ego argument, but the overlap between what the Ministry of Religious Affairs does and what the Trust does. Consequently, the defendant, by signing the MOU, was conducting an activity which falls normally within the functions entrusted to it by the applicable rules. At 8.3, thereafter, it was the defendant, by an act of sovereignty, took the decision to establish the trust on the 14th of February, pursuant to Section 3 of the Ordinance, in exercise of powers conferred by Clause 1 of Article 89 of the Constitution, which empowers the President to promulgate an ordinance when the National Assembly is not in session. Next paragraph, it was the defendant that defined the objects of the trust and determined the functions that were to be delegated to it, and that included the function of adopting measures for facilitating the performance of Hajj. Then it goes on to deal with the overlap of the functions dealt with by the government and the trust. And then 8.4, the organic control of the defendant over the trust, resulting from the ordinance provisions regarding the composition of the board of the trust, the government's prerogatives as to certain functions, though insufficient to lead to the disregard of the separate legal entity of the trust, as explained above here, constitutes nevertheless an element of evidence as to the true intention of the defendant to run and control directly and indirectly the activities of the trust. And this part is not open to me to view the trust as one of its instruments, because I'm not arguing alter ego. He then again goes through the various parts of the ordinance which we've been through. 8.5, this conclusion is confirmed by the continuous involvement of the government in the negotiations with the claimant despite the establishment of the trust. In fact, before the signature of the agreement and in spite of the recent establishment of the trust on the 14th of February, all correspondence concerning the finalisation of the pending matters in the project continued to be exchanged with the government itself, MORA or Ministry of Finance, and not with the trust. They then refer to a series of letters. Page 30, the conduct of the defendant at the time of the signature of the agreement.
Do we have those letters? Are they all in the
I
bundle?
believe they're all, and I think they were only an example.
Yes.
Right. It is the defendant that decided to delegate to the trust the finalisation, signature and implementation of the agreement with the claimant, which the defendant had negotiated pursuant to the MOU of July 1995, and which appeared to be the main purpose for the establishment of the trust. It said it was signed by the Minister of Religious Affairs, acting as chairman of the board. It refers to the successive promulgations. At 9.2, the defendant was contractually involved in the agreement as the government was bound under Article 2 to give its guarantee for the financial facility to be raised. And the point I made earlier, that the guarantee was not a guarantee of its performance, but it was the trigger to enable the finance and the whole contract to begin. Under Article 27 of the agreement, it was authorised to assign its rights and obligations to the government, i.e. to the defendant, without the prior approval of the claimant. Such a clause is normally used only when the assignee is very closely linked to the assignor or is under its total control through ownership management or otherwise. Then the period of performance. During the lifetime of the agreement, the defendant continued to handle matters relating to the agreement signed by the trust and to act to conduct itself in a way that confirmed that it regarded the agreement as its own. And then it deals with, beside the exercise of the regulatory powers, undertake, officials of the defendant continue to be actively involved in the implementation of the agreement as they were previously in negotiation. It refers to the two letters of 26th of September 1996 and 4th of November. Those were the two letters I showed you relating to the implementation of rules for the funds which had been set up, and it's right that they had in fact been set up by the trust. And it then at 10.2, although the trust enjoyed under the ordinance legal and financial independence and capacity to own property and assets and to dispose thereof, it does not appear from the actual facts as submitted by the parties that the trust effectively had any funds or assets of its own during its short lifetime. There's no evidence of any schemes or plans made to raise funds and to mobilise pilgrim savings, nor of any transactions made and implemented by the trust for the purpose of generating funds to finance its activities. Apparently, it seems as if the only activity conducted by the trust was the signature of the agreement with the claimant, with the implementation being followed up by the Ministry of Religious Affairs itself, and as if the trust was not given the human and financial means that could have enabled it to exercise fully its functions as an autonomous legal entity, and has therefore remained as an empty shell with all effective powers being exercised by the defendant itself. It was the government which decided, by a discretionary act or omission, not to re-promulgate the ordinance, the end of 4 months from the date of its second re-promulgation, and therefore to put an end to the trust on the 12th of December 1996, pursuant to the repeal of the ordinance as a result of its non-re-promulgation. The very existence of the trust appears thus to have been depending merely on an attitude of non-action by the government, demonstrating the fragile existence of the trust and its complete dependability upon the government, even for its own life. And then it refers to the letter of January 1997 and summarises the letter in the first paragraph on page 32. The second paragraph, such letter is very significant because it confirmed in the clearest way possible that the defendant, after the elapse of the trust, regarded the agreement with the claimant as its own and considered itself as a party to such agreement, and as such was entitled to exercise all rights and assume all responsibilities provided for under such agreement.
So he's assuming there that Mr. Mufti was writing as secretary of the defendant, isn't he? I mean, that must be.
I think it must be, yes. But he explains why. It's significant also to note in this respect that the defendant's position in these arbitration proceedings regarding the letter of the 19th of January did not deal with the substance and contents of such letter, but was rather limited to a formal and very general challenge of the validity of said letter on the ground that such letter was absolutely unauthorised, illegal, and of no effect, because all office bearers of the trust, including the secretary, had ceased to have any authority to act for the defunct trust. Such challenge is, however, completely unfounded, as the signatory of the letter of the 19th of January 1997, Mr. Lutfullah Mufti, did not sign such letter in his capacity as official for the trust, to which anyway the letter makes no reference at all, but in his capacity as secretary of the defendant, the Ministry of Religious Affairs, which is an integral part of the government of Pakistan. As such, the signatory of the letter engages and binds the government, as he has continued to bind it during the whole previous period where the trust was in existence. In consequence, the signature of the said letter by the Secretary of Defendant may only be explained and construed as another evidence of confirmation that the defendant considered itself a party to the agreement, exercising the rights and assuming the responsibilities thereunder. The fact is the more significant because after the elapse of the trust, the defendant could have remained silent and have abstained from any involvement with regard to the agreement signed with the claimant on the ground that it was not a party to such agreement and therefore was not concerned by it. that the defendant, on the contrary, took the initiative after the elapse of the trust and wrote a letter in its name to the claimant, involving itself as a party to the agreement and treating such agreement as repudiated. Such conduct of the defendant clearly confirms that this latter was acting as a contracting party to the agreement in a quite unequivocal way.
So all of that is built up onto the letter of the 19th of January.
Yes. In the light of the fact that the ordinance had not been repromulgated.
Is there any reference in this award to the first set of Pakistani proceedings?
Yes, we come to them in a minute.
But not in this context?
Not in the same way as the learned judge referred to.
Well, isn't that an important weakness in the tribunal's reasoning, that it doesn't evaluate its conclusion that the signature can only be explained and construed in one way against the relevant background, the same day, what was going on?
Well, it evaluates the Pakistan proceedings in a slightly different way.
Well, it deals with the second set, because
Yes.
that favours its conclusion over the page, but I notice it doesn't deal with the first
My
set.
Lord, I accept entirely. It doesn't make that point.
Well, then we can't put much weight on this
Well,
as a process of reasoning. I mean, I see what it says, but the fact is that it recites one half of the argument and doesn't put it the whole picture.
it depends to what weight there is to be placed on that, on the 1997 proceedings.
No, but you've got to at least evaluate it. They haven't considered the point. And possibly because this was a one-sided process. There was written submissions from the government of Pakistan, but not oral submissions. And you don't necessarily appreciate all the points which can be made until you've heard tripartite argument.
But if even though they didn't evaluate it, it wouldn't have made any difference, then it may not matter.
Of course.
The other thing that strikes me about this, just the context of this, is the first part of the analysis it very much stresses something close to the sort of alter ego point. I mean, the first part of the analysis is all about how really the trust just a shell, all the people it wasn't really the trust personnel who were calling the shots, it was the government. It's something close to a sham, really, or at least something. It was a creature, if you like, of the government. Whereas that's not part of your case now, is it?
No, but of course, when you look at it in the round, they are looking at the end letter, as you have seen, is regarded as very significant.
Well, the one we've just been looking at.
The one we've just been looking at. And that, in a sense, the end part, in the light of what I've shown you from Mr. Durand, it would be enough under French law. Can I just finish this and then perhaps compare what Mr. Justice Aiken said? Really, paragraph. Yes, subsequently, after the letter of repudiation, the defendant continued to consider itself as a party to the agreement, instituted proceedings before the Pakistan courts, well before the notification of the request for arbitration claimant. So it does refer indirectly, but I appreciate, as Lord Mount says, it doesn't tackle that particular issue. Under such judicial proceedings, the defendant in the second set of proceedings, from June 1998 suit, while alleging the agreement with the plaintiff was no more binding because it had been repudiated, admitted thereby it was a party to such agreement and that it could accept repudiation of the agreement by the claimant. And then it deals with the Pakistan proceedings. If I go to 12, in the aforementioned close scrutiny of all the factual elements relating to the conduct of the defendant with regard to the negotiation, signature, implementation and termination of the agreement, as well as with regard to the establishment, operation and expiry of the trust, it is clearly established that the trust established by the defendant was assigned an object, formed part of the functions of the defendant, was organically and operationally under the strict control of the defendant. Moreover, its financial and administrative dependence was largely theoretical, as it didn't have any funds or assets of its own, and as all that concerned the agreement with the claimant, whether before or after signature, continued to be performed by the defendant concurrently with the trust. Following the lapse of the trust functions that were originally discharged by the defendant reverted back logically to this latter, with all rights and obligations of the defunct trust. The trust, in spite of its distinct legal personality in theory, appears thus in fact and in conduct to have been considered and to have acted as part of the division of the defendant, to which it is fully assimilated, a temporary instrument that's been created by a political decision of the defendant for specific activities which the defendant wanted to perform, and which was cancelled also by a political decision of the defendant. Therefore, the trust seems to have appeared, now this is the alter ego point, have been no more than the alter ego of the defendant, which appears in substance as the real party in interest, and therefore as the proper party to the agreement and to the arbitration with the claimant.
But unless you're willing to espouse that, then that does rather undermine, at any rate, a significant plank of the reasoning of the tribunal.
It undermines a part of the plank, but part of this also goes to the other aspect of common intention. If one reads on, I've nearly finished, and the defendant identified as the Ministry of Religious Affairs has been in actual fact the party that was involved. So he deals with two grounds, really. He deals with the alter ego. Then he says that the Ministry was involved in the negotiation, implementation and termination of the agreement with the claimant from the first day that the housing project was contemplated until after the repudiation of such agreement. This was and remained true before, during and after the existence of the trust, with no change being notified in the role of the defendant, whether during the lifetime of the trust or after its elapse. Such behaviour shows and proves that the defendant has always been and considered itself to be a true party to the agreement with the claimant and therefore to the arbitration agreement.
So they seem to have thought that they were interchangeable, so that any obligation of the trust was an obligation of the government.
Well, it would appear, looking at this, that really there were two planks of the reasoning. One was the alter ego, but the other was the common intention test.
Yes, but they both led to the same conclusion.
They both led to the same conclusion.
Namely that the obligations of the trust were also the obligations of the government.
And that was so all the way through, really.
I'm sorry,
that was so all the way through,
yes.
is what they're really saying.
Yes. Certainly many, but it then goes on to say, certainly many...
Including the waiver, for example, of sovereign immunity.
Well,
That would be the logic of that, at any rate.
well,
You don't seem very keen to go that far, but to the...
certainly many of the above-mentioned factual elements, if isolated and taken into a fragmented way, may not be construed as sufficiently conclusive.
Yeah.
However, Dr. Marmasani believes when all the factual elements are looked at globally as a whole, such elements constitute a comprehensive set of evidence that may be relied upon to conclude that the defendant is a true party to the agreement with the claimant, and therefore a proper party to the dispute that has arisen with the claimant under the present arbitration proceedings. Whilst joining in this conclusion, Dr. Shah and Lord Mustle note that they do so with some hesitation, considering that the case lies very close to the line. Such a conclusion finds additional support in the general principle of good faith that should preside over the implementation of agreements, as well as in the general requirements of morality and fairness that should not be ignored in international transactions. In the view of Dr. Marmasani, these general principles command and require that a state which is a party to agreement through a state-owned entity should not be able to avoid its obligations by having such entity made insolvent or by ending itself the existence of such entity. Such a situation, by leaving the other contracting party without any contractual counterpart, without any protection as to its rights, is unacceptable, unfair, and contrary to all requirements of morality and good faith.
I'm not sure you need to read the rest of this. I mean, it's all on the good faith point, isn't it, to the end
I think
of the...
the rest is, my lord. Now, let me come to Mr. Justice Aikins, and in the interest of time, I'm going to concentrate on one or two key points, which is...
So just finally on the good faith point, that was really a minority view, wasn't it?
I'm sorry. Well, it was... basically, what was said is that...
It was a minority view which comforted the conclusion that the trust was an alter ego and therefore a party.
Except the duty of faith applies, not convinced, yes. But nevertheless, are reassured that it conforms to the general justice of the case. And then you have Mr. Justice Aikins at D, and if you go to paragraph 105 at page 359,
We're back in B, are we?
No, same bundle, my lord, the core bundle,
Yes,
cool.
right,
Sorry,
and
one-
454,
359,
359. Thank you. Right.
paragraph 105.
105.
Very long passage dealing with all of this.
I'm sorry?
Are you going to read out
No,
all
I'm
of
not
this?
here.
You set it out quite fully in your case.
Yes. I was just going to point to a couple of points. In particular, I was going to go at this stage to paragraph 115. The arbitrators also relied on the fact that the government took a decision not to re-promulgate the ordinance. They say that this was an indication of the government's intention. I find this difficult to follow. It's correct that a new administration took over the GOP on the 6th of November. I would be prepared to infer that the new government made a positive decision not to re-promulgate, but I do not see why, logically, that leads to any conclusion that the GOP intended to step into the shoes of the trust, which would cease to exist under Pakistan law once the ordinance stood repealed. There's no logical reason why that consequence should flow from the decision not to re-promulgate the ordinance.
That's a succession point, isn't it?
Well, it may be, but if it's a wider point, my lord, I've made the point, I think, earlier as to why the government might well want to dot the I's and cross the T's and ensure that there was no further recourse against them. He then refers to the termination letter. And my lord, the key bit is in paragraph 19. The best evidence, right at the bottom, I have the state of mind of the secretary. Sorry, this is the best evidence referring to the Pakistan proceedings. I have the state of mind of the Secretary of War at the time. It indicates that he, on the part of the GOP, thought that the trust had rights it could enforce. It does not indicate an intention on the part of the GOP to be bound by the agreement or the arbitration clause, or any intention to step into the shoes of the trust. My lord, I've made my submissions on that. We submit that is too simplistic a view of what happened at that particular time. It's easy to read into that without knowing, because there is no evidence, what happened. What is the argument that it may have been a mistake is without any evidence. And as I said to your lordships earlier, it could equally be for tactical reasons. We simply don't know. But what we do know is that Mr. Mustafa Lufti at the time was not a secretary and never had been secretary to the trust. He was only himself secretary to the minister. He wrote on ministry note paper. The trust had never got round to, or never, in fact, established any note paper. If he was writing on behalf of the government, one might have expected him to say, because that was the only capacity in which he was writing, this is, I'm not writing on behalf of the government. I am simply writing to make sure that although the trust has ceased, that insofar as the trust has any rights, we wish to make it clear that no such rights exist by reason of your repudiation.
He does make the point that paragraph 10
of what, my lord?
I'm looking at the Judges 119.
Yes.
And about 8 lines into that paragraph 10, he said, refers to the alleged defaults of Dallah and states that this, quoting, repudiation was accordingly accepted by, and I think in shorthand, the trust.
You've lost. I'm sorry, I'm lost.
119.
119.
I'm sorry. It's just that the point being made against you, I think, is that here is an attempt at analysis, trying to get to the bottom of this, and quite a telling point, one might think, is what he's able to say about paragraph 10, and the fact that the writer says the repudiation was accordingly accepted by the trust, vide its letter dated the 19th of January 1997.
Yes, but of course you will remember the following year it said this letter was accepted by the new plaintiff.
Well, Mr. Mufti, if he were there to be cross-examined, would be in some difficulties about the...
But he wasn't.
I follow that.
No.
The contrast between the various different things he was quite willing to swear as being true.
But it
And
must...
a cynic might say, the trouble with all this was the government had decided they didn't want to have anything further to do with this, and they were taking every conceivable point to achieve that end. They were doing it in a rather scattergun approach without anybody giving any real thought to it all. That would be a cynic's approach. I'm not quite sure how that stands with the arguments on either side in this case.
But if that is a cynic's approach, that means that the government, as the only party that could possibly at the time be a party to the agreement, is actually the party that is intending to make sure it's no longer has any risk of there being a claim made against it.
That's really partly the good faith point, isn't it? That if that's the view you take, well, good faith would say you can't accept
Well,
that type of
the
risk.
justice point, yes. I mean, I wouldn't go so far as to allege bad faith in the sense that against the government in the sense that we know.
Mind you, it's a big step from that to say that they must have intended to be a party. I mean, I could see you could have a bad faith point, which might succeed as a bad faith point. But to my mind, it's a big step to say that if the government's attitude was something like that they must have intended to become a party. One might have thought that's the last thing they'd have intended.
Well, one might under English law, my lord, but of course we're looking at French law.
Well, whoever's law you're thinking about, if you're stepping back and looking at the realities in this kind of situation, which presumably even the French law does, or perhaps particularly does.
Well, I showed you the evidence. I mean, the fact is, if you behave in a way that indicates, this was the point that the tribunal took out, if you behave in a way which indicates to objectively what your subjective intention might be, because why write that letter? It just wasn't necessary. And the only reason to write that letter is to protect what you thought, the government thought, were potential recourse or claims against it.
I'm afraid you're assuming, in my eyes, what you've got to prove, in the same way that the tribunal looked at the argument and thought it was the only possible analysis. I don't think what you've assumed is the only possible analysis. The issue we have to grapple with is what makes better sense overall, and one interpretation overall is that the first set of proceedings were conducted on the basis that the trust was party, and the letter was written entirely consistently with that. When the judge, at your client's instance, struck them out on the basis that the trust had, it was now pointed out that the trust had ceased to exist, the government, rather unwisely, in response to the Paris proceedings, took up the idea that it might be regarded as a party and could take counter proceedings in Pakistan. That's the alternative you've got to grapple with.
The problem being that there isn't any specific evidence.
Yeah, you say, well, the burden of proof's on them. They could perfectly well have produced some evidence about all that. They chose not to, no doubt, as part of a tactical plan. Or even,
well, I don't know. I'm not
incompetent.
saying it's a tactical plan that they didn't produce any evidence to this.
Well, maybe not. They were, or they did it. They either chose not to.
Yes.
But whatever the reason, there's no evidence. I mean, that's the sort of line you have to take.
Well,
Yeah, and
when I've shown you, of course, the correspondence with the ICC.
yes.
My lord, I was now going to move on away from the facts to the...
Is there anything more you want to take out of the judge, or is that it?
I don't think so at this stage. I might come back to it when arguing the law, but I don't think there's any other points, because the key difference was that termination.
Yes.
I mean, the judge, to a certain extent, was prepared to accept more or less what the tribunal had said in relation to the other matters. The key difference.
Yeah.
And it is important when you're looking at the legal issues, which we'll come to now, that the very point Lord Vance has said, we don't really know, and therefore, what is an enforcing court to do in such a situation? And perhaps I can come to that now.
I mean, suppose, just a matter of interest, you say that letter, if the tribunal's right about it, carries you the whole way, does it? It automatically means that the government of Pakistan must be regarded as having been party from the outset, or as having become party by voluntarily acceding in some way, or what?
I can put it in three different ways. I can say, first of all, that
it is effectively the clinching piece of evidence when you look at the whole scene from beginning, the negotiation, the performance, and this is the termination. I can say also, secondly, that it is, has to be looked at in the context not only of the letter, but of the termination or the failure to re-promulgate, which was in itself effectively brought about the termination of the agreement. So that one is looking at the whole period from December to January. And finally, I can argue that even if I'm wrong on both those, the letter in itself would be sufficient to entitle my clients to say that the government became a party by their conduct at a later stage.
And why? Is that for the reasons the tribunal gave, is it? Because he
Because
signed
yes.
as secretary, because of the letter heading?
Because of the letterheading, because they didn't need to do it at that stage. And of course, it's all based on French law.
Is there any evidence that it was your... I mean, I think the difficulty I have about that is that we're talking about common subjective intention, presumably at the same moment in time, and you've accepted that in January 1997, Dallah thought that the trust continued to exist, and so there's no evidence that it thought that the government of Pakistan was party to that agreement at that date. It didn't allege that until 15 months later.
Well, I'm not sure that's quite accurate, my lord. On the 26th of January, we haven't got the letter, unfortunately, but it is at least arguable that they wrote back to the government saying, because that was with whom all the correspondence was in any event, don't repudiate, carry on. We don't know when my clients discovered that the ordinance had not been re-promulgated. All we do know was at some point in the proceedings, it may be there's a reference to the last date, which may be the last hearing. It may be later on that it was discovered. But it wouldn't necessarily be something that my clients would necessarily know at the time. But it was, at any event, discovered at some point.
Yes, but the mere fact they discovered it doesn't mean to say that they thought the government was party. They may have discovered the trust had existed, racked their brains, and then after a bit decided that must mean that the government was party, especially once they got the judge's tip in that direction in, I think, February 1998.
But they took the point that the trust was no longer in existence.
Yes, exactly. But that doesn't mean to say they thought the government was a party, just because they thought the trust no longer existed.
Well, at that particular point in time, one doesn't know, of course, what was going on in the proceedings. At that particular point in time, they were trying to defeat an injunction against them, brought by the trust. The issue at that stage may not have been who was a party for the purpose of the arbitration proceedings. All they were seeking to do was to try and stay the proceedings or get themselves out of the injunction, because what was being sought against them was not only declaration but injunctions.
Well, you're coming on to deal with the law. You're coming on to deal with the law.
I think you said. To deal with the law.
Well, I wonder, I mean, in view of the time, it doesn't seem very apposite to start that.
My lord, what I was proposing
No, but I'd just
do,
like to see what the general programme is. I mean,
yes,
if you
what
could
I
help
was
us.
proposing to do, parts, I think it's 3 and 4 of my case, I indicated at the outset, was really put in by way of background. And I wasn't endeavouring to, other than very quickly, I think it's part, let me just check I've got the right part number. Yes, part 3, which is enforcement under the New York Convention, and part 4, jurisdiction, is set out in great length in my case, and I did indicate that the purpose of that was to try and focus what I said. I think a large part of that's not controversial, but it was simply to give your lordship some background for the purpose of my argument. I would hope, therefore, to be able to canter through that pretty quickly tomorrow morning and get straight on to the first issue,
Yeah.
which is the issue of the extent of the review. The actual issues, once your lordship is familiar with the underlying facts, are relatively short. Again, I have cited quite a lot of the cases, the relevant passages at length in the case, rather than having to trouble you with actually having to go to all the authorities, and
Yeah.
I will therefore be selective as to the authorities to which I go tomorrow.
Yes. Well, you said you set yourself a timetable of 5 hours, which means you've got 1 hour left. I think there's a certain amount of latitude, but perhaps you can have a word with
We'll have a
Mr. Landau and just be quite sure how the time is to be spread between you. I'm afraid we don't sit until 12 o'clock tomorrow, but we've got effectively 3 hours tomorrow and then 4.5 hours the day after. But if you can finish a little earlier, that would be helpful.
We will bear that in mind.
Tomorrow at noon, then. We look forward to seeing you. Thank you very much.